So the Supreme Court has issued an order in a critical Second Amendment Preservation Act challenge that was pending in front of them. And now this is heading back to the lower court, but there are maybe some shenanigans that are also going on from the Trump DOJ. So let's talk about what is happening in this critical case. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe, and then also double check to make sure YouTube is not unsubscribed to you, because they love to do that, especially on two-way channels. I also want to thank one of the main supporters of this channel, which is 1st Phorm. You guys know that 1st Phorm is an amazing company, pro-freedom, pro-America. They support the Second Amendment, but also they're an amazing company that has supplements, apparel, all of those things that you need. Potentially, if you have a New Year's resolution and you're trying to get healthier. One of my goals right now is to work out more. I'm working out 4 times a week, 10,000 steps a day, staying on top of my macros and calories and all of that. And I'm using a lot of the 1st Phorm supplements to help me along that journey. So if you guys are interested, check them out using the link down below. And if you use that link and you order any supplements, you can get a free 5-pack of protein sticks. Now, as I mentioned in the intro, in this video, we're going to be talking about a huge Second Amendment protection case that was seeking Supreme Court emergency review. This is a case dealing with a state's Second Amendment Preservation Act, and we've discussed this case in the past because prior, the Supreme Court issued an 8-1 order denying an emergency stay, which would have protected Missouri's SAPA law and the protection there that would have actually allowed it to go into effect at least temporarily. This case recently went back in front of the Supreme Court and we got an answer from them. And the Supreme Court in that recent order list denied emergency review to this Missouri SAPA challenge. But despite that, this case is not yet done. Now, you might remember that in this case, the Trump administration continued to argue that the SAPA law is invalid in some of its applications and that the Supreme Court should ultimately deny review to this case. However, at the same time, the Trump DOJ also stated that if the court denied this review, the government here would release some of the total judgment and injunction that they received from the lower court. The administration told the Supreme Court that once this case got back in the hands of the lower court, the district court, they would release at least part of that total judgment. Missouri responded to this by pointing out the concession here made by the Trump DOJ was exactly why the Supreme Court should actually grant review to this case, because the 8th Circuit ruling would still stand in this case. But ultimately, after this went to conference, the Supreme Court decided to deny review to this case. Ultimately, it seems like the Supreme Court took the word of the administration that if they deny review to this case, the door would kind of be open for the administration to remove some of that prior ruling, in the lower court. So maybe that's why they denied that request. However, to this point, even months after that denial, the Trump DOJ has still not moved in the lower court to remove that complete injunction that was issued in favor of the Biden administration. Now, this lawsuit revolves around a 2021 Second Amendment Preservation Act that was passed in the state of Missouri. That law set the state's interpretation of the Second Amendment and set restrictions on the support and funding that the state would provide to federal agencies in their attempts to enforce federal laws that the state believes violates the Second Amendment. The law prohibits Missouri's officers, agents, and government officials from helping federal agents who are attempting to enforce those laws. The law also created this civil remedy where anyone, a resident of the state of Missouri, could sue a Missouri official if that official helped to enforce a federal law that the individual or the state believes violates the Second Amendment. So the law aimed to give the true enforcement powers to the residents instead of the state or any of its officers. Now, in this case, the district court on review ruled in favor of the then Biden administration who were bringing this challenge, and they struck down the Missouri Preservation Act in its entirety. Now, in response to that, the state of Missouri then appealed up to the 8th Circuit, and Missouri at that time wanted a temporary stay on the lower court's decision, which eventually led them to seek emergency Supreme Court intervention. However, like I mentioned, on review, the Supreme Court issued an 8-1 order denying that emergency stay request. Only Justice Thomas was in favor of granting the stay, which would have allowed this SAPA law to potentially be implemented in some of its applications while the case was proceeding forward. After the Supreme Court denied the review to this case, it went back in the hands of the 8th Circuit, who then held, arguments in this case, and then the 8th Circuit ultimately ruled in favor of the federal government, striking down the SAPA law once again entirely. But then in response, Missouri filed a writ of cert. Again, they went to the Supreme Court for emergency review of this case. And one of the big things that Missouri pointed out in that request was that the 8th Circuit essentially said that the structure and potential operation of this law is valid, but they ultimately struck it down because they did not like the underlying Second Amendment purpose. Missouri argued that the 8th Circuit went against clear precedent and found that state officials could be sued because the court believed that the state played a role in enforcement by simply complying with the state law. Essentially, the court there found that compliance and non-action was still enforcement, and therefore the state of Missouri was still on the hook. Now, this law was originally opposed by the Biden administration, but then the Trump administration obviously got control of this case and all the other cases. And initially, the Trump DOJ kind of stalled their response for multiple months in the Supreme Court, but eventually they then submitted their answer to this case in the Supreme Court. And in the response, the Trump administration continued to argue that the SAPA law was invalid and that the lower court kind of got the decision correct. However, at the same time, they argued that if the Supreme Court denied review to this emergency case and it got back in the hands of the lower court, the then, federal government, the Trump DOJ, would ultimately dismiss some of the total injunction that they received, or really that the Biden administration received in this case. They argued in that response that having reevaluated this case, the United States has concerns about whether the judgment below extends too far and enjoins applications of the act that do constitute mere non-enforcement of federal law protected under the anti-commandeering doctrine. And those concerns are exacerbated by the uncertainty in this pre-enforcement posture about how certain provisions of the act will be applied and about whether the provisions on which the Eighth Circuit focused are indeed inseparable from the rest of the act. They stated that given these concerns, the United States has decided that it would acquiesce in narrowing the scope of the judgment when the district court regains jurisdiction over this case. So after stalling the case for a few months, the Trump DOJ responded by continuing to argue that some of the SAPA law is still invalid, but that the Supreme Court should deny review to this case, and then once it was denied and got in the hands of the lower court, they would potentially release, motion for the lower court to release some of that total injunction that they issued before. Now, unfortunately, like I mentioned, the Supreme Court sided with the Trump administration in this case, probably because of that promise that they made. Now, despite that denial in this case, this case is not yet done, and it will still move forward. As the U.S. stated in their request for denial, once this gets back in the hands of the district court, we would assume that they would fulfill that promise and submit, some sort of release of that total injunction against the Missouri SAPA law. So there may be some ways in which the SAPA law will be implemented while the case moves forward to a final merits judgment. The larger concern now really is at what point will the Trump DOJ actually move for the lower court to remove that total injunction like they stated they would do at the Supreme Court level. We will now see if the Trump administration stays true to their word or if they will go back on that promise. But to this point, a few months after that denial, we have not seen any movement, in favor of removing those, complete injunctions. The Trump DOJ has not yet fulfilled that promise. So that, of course, is very concerning. So unfortunately, Supreme Court took the word of the Trump DOJ, denied review this case, denied review to getting involved in this issue. But there is still hope and potentially positive movement in favor of keeping some of the Missouri SAPA law in place. But now we're going to have to watch the Trump DOJ very closely to see if they fulfill that promise. So that's what's currently happening in this critical case. As we get more information, as it develops more, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All those things help to fuel the algorithm or Al Gore's rhythm. Like I used to say, it adds fuel to his jet, and it really helps these videos and this channel to get out to more people. So thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.